Devangna to introduce briefly what Pranesh does and then hand over to Pranesh. He will be the first speaker for today's event.
Thank you, Gaurav. I think for those of you who have been sort of following the open data revolution in India, Pranesh is not an unknown name. So he doesn't need an introduction, but I would still do it for people who are new to the open data world here. So Pranesh is a policy director, and he was also the part of the founding team of Center for Internet and Society. And Center for Internet and Society is one of the pioneering organizations in India around everything around internet. They are an inspiration, and I think a lot of organizations like DataLearn follow the work that CIS India does. He's also the legal lead at Creative Commons India and an affiliated fellow at the Yale Law School's Information Society project. He was also listed under the 30 list of Forbes India. His research interests lie in technology, culture, economics, and law. And he is an advocate of the open data revolution, internet privacy, and everything around internet. So I would probably not be the right person to talk about the work that you've been doing and the interest that you have. I think you are the best one to sort of tell about your passion. So.
Thank you so much. I learn new things about myself each time I do one of these talks. I am a lawyer by training, but I have been working in the technology policy space formally now for the past 8 years, and I've been involved in it in one way or the other for, I guess, for around 12 years now or so. So what I wanted to do today was, apart from answer the numerous questions I'm sure you're going to have, to provide a bit of an introduction to the legal and policy scene around open data in India, and from there also bring up some questions of ethics and power, because those are, in my mind, intimately linked to law and policy. First off, actually, this is a report that we at the Center for Internet and Society did in 2010, if I recall correctly. At that time, trying to survey the area of open government data, which wasn't really a big area at that time. There wasn't all that much to survey, frankly. Thankfully, CPGA was still around, and we went and spoke to them. They weren't in the open data area at that time yet, but they did provide very valuable input to this report. It's available on our website, and if you just search for the title, you'll find it, etc. And I'm happy to note that some of the recommendations that we've made, some of the things that we spoke about in this report have actually come true and have actually changed. So one of the things that we lamented in this report was the lack of civic hackers, right? How, when we look at other countries, when we look at, say, at that time I was looking at the UK, and later I've gone and met civic hackers in Egypt. Even looking at countries like that, there are far more people doing this kind of work than in India, the programming capital of the world, at least for outsourcing. And the Silicon Valley of India didn't have that very many. Tej was a very early inspiration for me, and he was one of the few people I could talk to about this. Now, there's this entire room, and many more who aren't here who are actually involved in this. So that's a great change that's happened since then. However, a lot of what we spoke about in terms of law and policy, in terms of the kinds of considerations that governments and other open data hackers ought to have? Well, those sets of issues haven't really seen all that much more clarity. There have been a few progressive policy changes, but again, not as much as I'd have liked to see. What we did in this report was to examine the roots of an argument for open data in India, and we traced that to the Right to Information Act. The Right to Information Act grounds itself in multiple areas jurisprudentially. It sees itself as part of Article 19(1)(a) of the Indian Constitution, which is the right to freedom of speech and expression. The Supreme Court has on numerous occasions held that the right to freedom of speech and expression contains not just the right to speak, but also the right to receive information. And the Right to Information Act sees itself grounded there, and in notions of transparent and democratic governance. So, and something that not everyone knows is that the RTI Act is not just responsive in nature. It's not just about reactive queries, not just about those situations where you ask a question and receive a reply. It also contains a provision, Section 4, which is on proactive data disclosure. And that, even though it's not as wide as we'd like, nor is it as nor does it have the same penalties as the rest of the RTA Act for not being followed. So a great many government departments don't actually follow Section 4 because they don't see the same penalties being attached to it as not following the rest of the RTA Act. That's quite unfortunate, but still, that's there, right? And that legal underpinning is what we said should be the legal underpinning for open government data. And I'm glad to know that in the National Data Sharing and Accessibility Policy, they do mention Article 9(1)(a), they do mention the RTI Act, and so that's great. Now, coming to the sets of problems that we said the government ought to have, ought to be looking at, some of which it still hasn't. Now, how many here know the difference between public data and public domain data? Put up your hands. Okay, so how many of you believe that it is okay to, if you file an RTI request and you get a response, is it okay to put up that response on the web or to publish that response on your blog, etc.? How many of you think it's okay, legally speaking? Well, all of you are wrong. And I do it all the time. Okay, just to be clear, we at CIS, we have put up, I think now, a few dozen RTI, if not more, responses we've gotten back from the government on RTI requests. We just, scanned them and put them up, apart from, of course, OCR and transcribe them, etc. But we do put those up. We're violating the law every time we do. Governmental data, which lots of us think of as public data, data the government has collected, made available, has published, stuff that is not covered by the Official Secrets Act, etc., stuff that the government wants to be public. All of that in copyright terms is not public domain data, unfortunately. So in the US, the situation is different, but the US is one of the few exceptions. In the US, governmental data is by default public domain. In most of the rest of the world, especially in Commonwealth countries, following the legal British tradition, government data is by default copyrighted.
What is the rationale for violating the law?
Why do we at CIS violate the law? Because it's a stupid law and should not exist. as simple as that. And well, I'd like to see someone prosecute us for putting up an RTI, the response to an RTI query, and I'd love to take that to court and actually use that as part of a challenge against this nonsensical law that just should not exist, right? By default, stuff that the government creates should not be copyrighted. Everyone should be free to use what the government creates. We're the ones who are paying for it in the first place. And the traditional rationale for copyright law, acting as an incentive for creation, etc., just does not apply to governments. There are better laws to use if something is not to be revealed or to be reused, etc. The better laws. There's the Official Secrets Act, there are things like that which are better suited to the task than copyright law. So that is an unfortunate situation. However, correcting that is very easy because all the government has to do, all that say data.gov.in, that portal that all of us love or love to hate depending on where we stand, all that they have to do, and let me just quickly, let me just give this a second. Oh, I'm not connected to the internet, I just realized. What am I supposed to connect to? Yes, why don't you just... So all that I want to show us, all that the government of, all that data.gov.in has to do is change this. Right here at the bottom it says, I don't know how many of you can see that. It says all rights reserved. All it needs to do is say some rights reserved. Okay, all it needs to do is openly license this under a Creative Commons license or under a carefully constructed open government data license. Now in India, in the UK, they need a separate license, an open data license. The reason they need that in the UK is that there are database rights also involved. Here in India, we don't recognize separate rights in databases. So there, it's not just copyright that they need to have license, but also these separate things called database rights. So they need a separate license. Here in India, it's only copyright. They could just use Creative Commons for this. Yet they haven't. The National Data Sharing and Accessibility Policy, even though we and other organizations in comment when it was in draft stage, we said please include this language on copyright, they refused to do so, said that it's an implementation issue, it's not a policy issue, which I really didn't understand, but even at the implementation stage, they haven't actually addressed it, which is quite unfortunate. Which means that the data that is on there, on this website, may well be copyrighted. Why don't I say is copyrighted? Because here's where we get into the minutiae of copyright law. And I am sorry if this bores you, but I've kind of been asked to come here and talk about this. So here we go. Not everything in the world is copyrightable. Not everything that is written is copyrightable. To get copyright, it needs to pass a set of tests, one of which is the test of it being original. Now, throughout, in different decades, we've actually followed different tests as to what we mean by originality in copyright law. At one point, up until 2006 actually, we used to follow an old standard called sweat of the brow, which essentially meant if someone sweated and expended effort and time in creating something, then that lent it originality. Essentially, if it wasn't copied and someone spent time in doing it, that was original. In 2006, this issue went up to the Supreme Court. And the Supreme Court held, overruling its past judgment, that no, just simply expending time and effort can't imbue something with originality. It has to be something more. That something more, frankly, by reading the Supreme Court judgment, I'm not sure what that is. It is one of two things. But in either case, it's not sweat of the brow anymore. So it's either the US standard of modicum of creativity. Okay, and in the US, this standard famously came up in a 1990s case relating to a telephone directory, to Yellow Pages, where they... Okay, I think I'm loud enough, and can I be... Yeah, so I don't think I need this. So in the US, they formulated a test called the modicum of creativity, which meant that a telephone directory, which a company called Vice created, that they could not claim copyright in it, even though they spent a lot of time and effort. They went house to house actually collecting this information and published it in new technology called CD-ROM at that time as well. Right? And it was copied. But the Supreme Court in the US held that that is not creative enough to be held to be original. That there needs to be a modicum of creativity. A tiny bit of creativity has to be there. Just an alphabetical listing of names does not suffice. Right? Now, there's a separate standard followed in Canada called the skill and judgment standard, which is another standard. So if some people see it as a slightly lesser standard and an easier threshold to pass than modicum of creativity. So if what you created involved skill and judgment, so it's more than just sweat of the brow, but it's less than modicum of creativity, skill and judgment, then you can have copyright. Well, in India, in this Supreme Court case, this 2006 Supreme Court case, the court cited both standards. I'm not sure which one they picked. I've read that case many, many times. I'm still, to this day, not sure which of these two standards they picked. Delhi High Court, in one case, said, oh, the Supreme Court actually picked modicum of creativity, and it went with that. This is a very pro-access to knowledge judge who was ruling on this, and so he went with the higher standard. But at any rate, the important point is that in India, we need something more than just sweat of the brow. Just because you spent time and effort in creating that does not give it creativity, does not mean it is original enough to merit copyright. Now, coming back to data.gov.in, that means that many of the data sets that are available there, which are just compilations, which are just, say, a list of 84 cities in which FM radio stations are there, those kinds of lists, in my opinion, cannot be held to be copyrightable. They are not original enough to merit copyright. So those kinds of things which are just plain data, probably, and this is again, I'm warning you, if you're relying on this is an untested theory, but in my opinion, as a copyright lawyer, in my opinion, I don't think this stuff, much of that stuff can be copyrighted. So it's under copyright. But data.gov.in doesn't contain only stuff like that. It contains information that you can say took skill and judgment to put together. It does contain information and data that you can say involves a modicum of creativity. So you have to, so is this stuff under copyright or not? There is no uniform answer. It, as lawyers are fond of saying, it depends. Now, that is the most complex, complicated part of what I wanted to essentially
So
bring to
can we
mind.
take an example in data.gov.in and say this is what can be called as copyrightable and this is what cannot be called as copyrightable? Some example.
Do you want to provide me some examples and I can
don't
take
have
a
any. Probably we can go right away and see
Sure.
in any one of these listings there. Just a random look and
data sets and health and family welfare. So I would say that things which are just indicators, which people went out and collected and just put it out in a very standard form, right? Not and that standard form doesn't in and of itself contain like any kind of analytical input, right? So if they haven't done they haven't done categorization, they've just done a kind of data dump of indicators, then that would not merit copyright. However, if they've done some analysis just in the way they presented that data, then that would merit copyright.
So meaning any raw data will be not copyrighted.
In a sense, yes. But if the presentation of the data, so at any rate, let's be clear about one other thing. Copyright covers expression, or at least it's supposed to, under the law, cover expression. It does not cover ideas. So if you look at the raw data, and if you write an article about it, then the article cannot be copyright infringement. So there was a case I remember a few years ago, it didn't get reported and didn't go far. There was a reporter who was threatened by the railways, by CRIS, CRIS. Oh, and this part has been public, right? But okay, I won't name names, but who was actually told that he can't that he has to retract an article that he'd written, which was analysis of some report that had come out. Now clearly it is, and he spoke to me and I think some other people as well, and I said it's clear as day that you're not committing copyright infringement, right? Using data, and so using that information in a different, and creating something of your own, that is not copyright infringement by any means. Copyright infringement is when you copy the expression, when you say reproduce the data, when you add some tags and take the data and show it as in different form, etc. Okay, that might be copyright infringement, but writing an article based on that information is definitely not copyright infringement. So copyright lies in expression. Now, obviously, that is a simple rule of thumb, but that's what the law is supposed to be. Over the years, we've seen a gradual expansion of what copyright covers. We've seen, for instance, TV show producers arguing that the idea behind, say, a Swayamvar, holding a TV show, reality TV show of the form of a Swayamvar, that no other TV show can actually do that. Now, that's a far stretch in terms of what copyright covers, right? because it's not actually copying of the expression. It's just taking the idea underlying it. So the idea-expression dichotomy, as it's known in the law, has been diluted over the years. Sure, but still the law recognizes this idea-expression dichotomy, and copying the idea, say the idea of a marooned sailor, okay, from Robinson Crusoe, creating your own story. That does not get covered by copyright. You're not committing infringement. Similarly, if you're taking data and you're creating and you're doing analysis on that data, that is not copyright infringement. What could constitute copyright infringement is if you're taking something beyond the ideas, right, represented in it, and going into the expression. So if you're copying lines from a poem, that would be copyright infringement possibly. If you're copying the tables themselves, that would be copyright infringement. And we do have a number of exceptions in India for things like private use. For educational use, there's a limited exception, and it goes from A to ZB, okay, section 52(1) of the Copyright Act if you're interested. But those exceptions generally tend to be very narrow and limited. Generally, we don't have a broad, open-ended, fair use kind of provision in the Indian law. Fair use, which many of you might have heard, is actually an idea present in American copyright law and a few other countries. Singapore, I believe South Korea also now has a fair use provision, and a few other countries like that. But that's about it. Most of the rest of the world does not have open-ended fair use. Now, what that means is if the barrier to get something, to make something original is pretty low. So if the way they categorize the data, okay, if even that is done in a non-obvious fashion, then that might be enough to say that that's copyrighted. So any other questions around this thorny issue?
So suppose I'm dealing with PDFs, a couple of PDFs data sets, and they include description, they include tables, they include some notes, metadata, and other stuff. What I extract now is a clean CSV machine consumable format, and I have to put that data somewhere in open on my GitHub account or some other portal or some other website. What sort of license I should use for that? And first of all, is it copyright infringement or not?
So I would suggest, and I've publicly stated this in other venues as well, I would say go right ahead. There's a chance be breaking the law. The chance that you get prosecuted for it are minimal, and if you get prosecuted for it, I'd be really happy because that will help us take the law down. Because right now, the situation in India with regard to things like the Copyright Act is that the laws are actually terrible. But no one realizes how terrible they are because no one gets prosecuted. Or few people get prosecuted and they're industry types fighting out amongst themselves, right? Or in other situations, they're the poor. So under something called the Gundas Act, okay, street vendors of pirated CDs can face preventive detention. Preventive detention is what the Brits used against political prisoners when they were in power, right? Where you didn't even have to show that there was something wrong that was committed. Now that we have extended to people on street selling pirated CDs.
Or books.
Or books or whatever. Now, so it's not people like us who really suffer from bad copyright law. If people like us did get prosecuted, then that might actually help reform the law and make it something better.